I refer the House to my chairmanship of the Justice for Families campaign, also Care Leavers Voice, which is a group of care leavers who are concerned that the voice of care leavers is excluded from the system. On the 14th of August this year, Jana Tokaljova, who is the press officer of the Slovak Republic's equivalent of the CPS, the General Prokurata, reported that their equivalent to the DPP had agreed with the Deputy Director of their National Police to appoint a special agent to investigate a criminal complaint of Sylvie Maher. The criminal complaint relates to care proceedings in the UK. This is an interesting process because it is an extra-jurisdictional process. I believe it relates to the Rome Statute, and as such could in the end result in members of the government facing questions as to why they've tolerated the amount of malpractice that goes on in care proceedings in England and Wales. On the 5th of December 2012, Leicester City Council fired a very experienced social worker because she wanted to send a baby home to its mum and dad. Her assessment was that the parents were competent, but Sir Martin Neri and the education ministers want a rapid movement to adoption, hence the baby remained in care. This pressure by local authority managers on a social worker to lie to the court is of course a criminal offence. However, I think the Slovak Republic is more willing to investigate criminality in our courts than the police in England. Happily, however, on the 5th of September 2013, this case was set down for a full hearing by an employment tribunal next year. I have for some time been worried about what I was told by a social worker some years ago. That is that at times the legally aid-funded solicitors for the parents conspire with local authority staff in order to ensure that the parents lose. One example where this appears to have happened is that of Jackie and John Courtnidge, whose two sons were taken into care because one had a lump on his head. The doctors were not sure whether this was a fracture or a fissure. The child was neurologically sound, which implies a fissure. However, the parents did not see the evidence that it could have been a fissure until after the court had decided in 2010 that it was a fracture, and the question was never considered in any court judgment. There was a court order on October the 30th, 2008, which said all evidence should be provided to the parents. This did not happen. The hospital provided Derbyshire County Council with the information in November 2008. This didn't get to the parents until after the finding of fact hearing in 2010 when they did a subject access request. The question is whether the council colluded with the parents' solicitors. Chris Sedgwick of Miles and Cash has been asked about the issue by his client and myself. Although denying the allegation, he has refused to give a detailed response, which to me confirms that Miles and Cash colluded with Derbyshire County Council to keep this evident from the parents. Additionally, there was a single metaphyseal fracture that Thomas Rosenfield Leventhal Markowitz found as long ago as 1990, that femur fractures often are accidental and that the femur can be fractured when the running child trips and falls. Pediatrics, Volume 88, Number 3, September the 1st, 1991, pages 471 to 476. Again, here we have an essentially criminal allegation which escapes investigation and prosecution in England, but could be prosecuted by the Slovak Republic. Article 3 of the European Convention of Human Rights was almost certainly engaged with the removal by the police of the newborn baby that appeared in the video that Staffordshire County Council failed to adjunct on Friday last. Interestingly, Mrs. Courtnidge assisted the father in resisting imprisonment at an earlier stage. Was the action of removing the newborn baby either inevitable and therefore permissible under Article 3 or even necessary under Article 8? The risk is future emotional abuse. The authority accepts that the parents are no immediate risk to their child. Why then take this action? The government is moving towards removing such babies and immediately placing them with adoptive families. This does not, to me, appear to fit with traditional English family law or the European Convention on Human Rights. I have mentioned Tony McLeod before, and she featured in the Sunday Express because Durham wanted to take her unborn baby into care because she went on an EDL demonstration. She went to Ireland. Sadly, the HSE in Ireland are now trying to force back to England all the family court refugees. More recently, she returned to England with refused permission to appeal in case reference to 2013 EWCI Civ 1007. In paragraph 10, the court said, happily, on one basis, this case is not about a mother who is incompetent or unable to provide ordinary, good enough, or even good physical and practical care for her children. Unhappily and frustratingly for all involved, I dare say, particularly the mother and the children, the concern about the mother's ability to parent is more subtle and harder to pinpoint, but it arises from her personality and the potential for the children to be upset by unpredictable words, actions or words that she may from time to time exhibit. there are still parents leaving the UK to escape the system. I know of 2 pregnant mothers who are doing this at the moment. One has gone to France and the other to live with a Belgian social worker who is appalled at what's been done in England and hence willing to look after a mother and child at home. I do welcome the work of Sir James Mumby. He is a very good appointment to the challenging task of President, and his initial practice directions have been good. However, the government remain complacent, and Parliament should really look at the individual cases. It remains that the care system itself is not accountable. The independent reviewing officer will never be independent whilst on the payroll of the local authority. Now, the issue of Jimmy Savile has been raised by various people. What is not so widely known, although it is in the public domain, is that a journalist, Leah McGrath Goodman, aimed to go to Jersey to investigate what was going on before it all became public. This was in 2011, but she was banned by the UK Borders Agency. After a period of time, in fact, the ban was removed through some effort from myself, and she got a visa earlier this year and has now been to Jersey. But obviously, the issues are now all in the public domain. However, the CCTV that might explain the basis upon which somebody was prevented from investigating a very serious case of child abuse, which did come out at a later stage, has still not been provided. And I think the government do need to give some answers on that issue as well. I wrote to all the embassies earlier this year, and I said to them, would you like to come to a meeting in the House of Commons to discuss problems with child protection? And we got 30 countries to come and 59 people there. And although not all of those countries have formally complained, we should recognise that there are some very serious concerns about how the system operates. Now, child protection is a very complex process. There's a very wide range of circumstances. There are some very good practitioners who work in this area. There's some very good lawyers. I said Sir James Mumby is a very good judge. There's a lot of good people, but there is also bad practice. And if we tolerate the bad practice, we undermine those people who are more competent in the area. So it is actually quite important that we look at wider issues. And in a sense, we have a constitutional problem. The constitutional problem is honourable members get complaints from their constituents. They write to the minister says, we don't comment on individual cases. Now, unless we actually are able to look at the details of what's going on individual cases and see if there are collective problems, we cannot be certain what's going on. I know the system does a very good job at times. I know it does a very bad job at times. But what we are not doing is looking at the process systematic. So you get a situation where the ministers say, we want more children adopted. That goes to the leaders of councils, who talk to the cabinet member for children's services, who talk to the senior managers, who talk to the more junior managers, and then the social worker who wants to send a child home gets fired. Or I had another situation with an expert witness who recommended that a child be reunited with its parents so the council wouldn't pay for the expert witness's report. Now, that sort of pressure on people to go in a particular direction is actually driven unintentionally by the government. I'm not saying the government intends to achieve these particular results, but that's actually what's happening on the ground, which is why... yes.
I'm grateful to my honourable friend, and I'm working hard to follow his argument. There are undoubtedly there's going to be injustice in the system, as there is in any system. But in terms of the case he talked about in Doncaster, where the social worker was fired for wanting to send the child home, that seems a little incredible. Could he say something more about it?
I have actually got the local authority, it was Leicester City Council's defence to the ET, where I can give you a copy of that, and you can see that in fact their defence is, we told her not to send the child home, but she wanted to send the child home, so we fired her. And that went to the appeal for the councillors in the authority who endorsed that process. And this is one of these questions, the balance between the civil procedure rules for expert witnesses. Social workers are experts. Expert witnesses are experts. Social workers do assessments. If their assessments are driven by management priorities, then actually they're not following the duty to the court. But in fact, what's happening is they're driven by management priorities a lot of the time. Another error the government's making is reducing the use of independent social workers, because an independent social worker is not necessarily, although what's called the repeat player prejudice is a problem, an independent social worker is not necessarily managerially driven to come to certain conclusions. whereas the employees of the council very often are. Now, the error made by the civil servants is they assume an assessment is the same, whatever the managerial pressure on somebody is. And actually, that's not the case. And there's a case, I think it's Larshin versus Russia, which looked at the question of expert evidence, and it concluded very clearly that expert evidence has to be produced by somebody who has no interest in the outcome or the conclusions. Otherwise, the cases are untrustworthy. So I think I'm coming up to my 10 minutes now, so I'll have to draw it to a close. But that fundamental issue about the quality of expert evidence, and actually the fact that a lot of it is driven by the management priorities of the local authority, is why there are a lot of cases that are really very bad. And this is something Parliament, your committee, could look at individual cases. The Honourable Member for the Justice Select Committee could also. All right. On that point, I think I've made my point, so I shall sit down.